Hello and welcome to Purposefully Prepared, Episode 5, Understanding the Secure Act and its Impact on Legacy Planning. The Secure Act stands for Setting Every Community Up for Retirement Enhancement. And while it may have done that for you, the account owner, it destroyed a very powerful benefit and advantage to children and grandchildren who might one day inherit that qualified account. So today we're going to talk about some of the positives for you, but then definitely the drawbacks for children and grandchildren if you wanted them to inherit the account and leave a legacy to those family members. The Secure Act was enacted December 20th of 2019 and became effective January 1, 2020. It does some pretty good things for the account owner in that it extended the time that you needed to take required minimum distributions, these are called RMDs, from age 70 and a half to age 72. So you get another year and a half to allow your account to grow tax deferred and to keep growing exponentially, compounding, which is very powerful, for an extra year and a half. These RMDs, or required minimum distributions, are the ways that the government gets its money back in the form of taxes based on the distribution that you take out starting at age 72 for starting January 1, 2020. The amount of the RMD is based on your life expectancy, and there's a table with divisors that will show you exactly what your RMD is. You can also refer to a CPA who can inform you of the RMD amount. Please know that if you don't take your RMDs or you forget to take them, that there is a penalty associated with that. The amount not withdrawn is taxed at 50%. Now, while that is a steep, severe penalty, it is easily overcome by simply taking the RMD. One of the other benefits for the account owner is that you can continue to contribute to your qualified account after you turn 70 and a half, provided you have earned income. What the Secure Act essentially destroyed is the benefit for non-spouse beneficiaries. This is referred to as stretch out. So before the law change, you were enjoying this tax-deferred compounded growth. And even though, let's say, you were taking your RMDs, your account was likely still growing because that's how powerful the growth is within that retirement account. It's actually unique and not like any other asset in that respect. Before the law change, your children could inherit that account. And if they didn't withdraw it immediately as a lump sum upon getting it, they were actually able to resist that urge, and instead they kept it as a retirement account. They would, under the old law, have to begin taking required minimum distributions, RMDs, in that year of your death and every year thereafter. But the account would still be growing, again, tax deferred, and compounded. So to the extent that your child had to take RMDs, they just paid the tax on that amount. And that amount would have been a lot lower than your amount because their withdrawal is based on their life expectancy, much longer than yours, according to the tables. And so their amount that they had to withdraw was smaller, giving the opportunity for the rest of the money in the account to grow. This also then could have been passed on to grandchildren, from child to that child's children, and still enjoy that same stretch out. And so there was a study done showing a $250,000 qualified account of yours in the hands of your grandchild upon their retirement age, whatever that's determined to be at that time, grew to $13 million. Now, there were some assumptions to that study. So the children that were taking the RMDs we're actually investing those distributions in another separate account that was also earning interest, just like the qualified account was. And they were very disciplined. So instead of falling to the temptation of just blowing it, they actually invested the money and kept it growing in this compounded way within the retirement account, and then in a separate account, just growing at regular rates. This, I think you would agree, is what we call legacy. To be able to turn $250,000 of yours to $13 million in your grandchildren's and their descendants' lives. Pretty powerful. Well, the Secure Act removed that ability, and now for all non-spouse beneficiaries, other than siblings of the account owner, for example, that are not 10 years younger than the account owner, all those beneficiaries must withdraw the IRA within 10 years. In the 10th year, they'll be forced to liquidate their qualified account and pay the taxes due in the 11th year. The way to mitigate that would be your beneficiary's choice. Perhaps instead of waiting until the 10th year, they take increments of 1/10 every year, or to help mitigate the tax burden. While they don't have to take RMDs during that 10-year period, they only get to enjoy that tax-deferred compounded growth for 10 years. And once that 10-year period ends, it will be forced out and they will pay taxes in the 11th year. So instead of getting 100% of that account, they'll only get 60 to 70% of that account based on what their tax bracket is. Nevertheless, there are ways to optimize that 10-year period. So we can flesh that out with you. So you can set up a meeting with us and discuss the ways that you might do that. Be sure to join us for our next Purposefully Prepared Episode 6, Uncovering Veterans Benefits. I look forward to having you join us.